Hi there. My name is Jonathan Ginsberg. I'd like to discuss with you kind of an unusual situation, but it's one I've seen several times in the last few years, and that is what happens if a claimant dies while waiting for a hearing or in the middle of the whole Social Security application process. And with delays going a year and a half, 2 years, even longer, this is something that has happened. I've had it happen 2 or 3 times in the last year alone, where a client of mine passed away while we're waiting for a decision, waiting for a hearing date to be scheduled. And the answer is that the claimant's survivors, the spouse and or children, can elect to go forward with the disability case. And literally what happens is I try the case with the spouse or the children standing in for the deceased claimant. And obviously what we're trying to show is that notwithstanding the death of the claimant, that before he or she passed away, this person was disabled, this person was not able to work because of a medically determinable impairment that had lasted at least 12 consecutive months. And it doesn't necessarily mean, and here's the takeaway from this, it doesn't necessarily mean that the cause of death is related to the disability. So in other words, you may have a person that died of a heart attack, but the claim for disability could have been on back pain. But if the medical records are appropriate, if the medical records show that this person, the deceased claimant, had serious back problems such that he would not have been able to work because of those back problems, it doesn't matter that he died of something else. He can still be found disabled. And generally the judges treat the claims of deceased claimants like closed period cases. What I mean by that is that obviously there's no ongoing benefits. You're only going for a period of disability starting from the onset date to the time the claimant passed away. And a lot of times judges are willing to give people the benefit of the doubt, A, because they know that your loved one is no longer with you and they feel some compassion for you in that regard. And secondly, because it's a closed period, these judges are not giving somebody a period of permanent disability. It's just going to be for a certain number of months. So a lot of times judges will give you the benefit of the doubt as far as your testimony about what was going on. And of course, you will have to testify about what you personally observed your spouse, your father, your mother was going through prior to the time he died in terms of limitations arising from his physical disability. So the answer is you can pursue essentially what amounts to a closed period of disability for the time that your loved one was alive prior to the time of death, and continue on with the case. And if you recover, if you're successful, you'll get a lump sum representing the past due benefits for that person. And of course, if it's a long time lump sum, it can be several thousand, tens of thousands of dollars, which can be certainly a nice legacy for your loved one to leave you with. So this is Jonathan Ginsberg. I hope this has been helpful in understanding what happens when a claimant dies while waiting for a hearing to be scheduled. Any more questions, feel free to call me or send me an email. And until next time, I'll talk to you soon.